Bankruptcy is also known as the Fresh Start Law. And the purpose behind the law was to give individuals and businesses an opportunity to reorganize their finances so they could carry on productively in society. There are 3 chapters commonly employed in bankruptcy. Chapter 7, the liquidation process. Chapter 13, reorganization for debts up to a certain level. And Chapter 11, which is reorganization for businesses traditionally, and now also for some individuals and businesses that have debt over the limit allowed in Chapter 13. In Chapter 7, the goal is to eliminate all debt, have that debt discharged, and that process takes about 110 days typically. And in the process, you prepare a schedule and petition that lists all of your assets, lists all your liabilities, and then go to a brief meeting with a trustee, which is an individual appointed by the court to oversee your case, and determine whether or not there are any assets that are eligible for liquidation. The trustee's job, therefore, is to find an asset that is not exempt in some way. Exemptions are the tools that we use to protect assets that you have, and California has a very strong set of exemptions, probably the 3rd strongest set in the country. In fact, we have 2 different sets in California depending upon what your needs are in terms of real estate or personal property. And the attorney's job is to apply those exemptions in such a way that you come away with all of your property intact, or at least all of the property that you wish to retain, come away with that intact. And in fact, nearly 98% of those who go through a Chapter 7 do in fact retain all of their property. But it is a bit of an art form to apply the exemptions in such a way to get the best possible result. In Chapter 13, however, that's a reorganization, and the trustee in that case is not seeking to take anything away from you, but the court is going to impose a requirement that you make a payment for 36 or 60 months, depending upon your income level, to repay some portion of the debt that you've incurred. And the amount of money that you're going to make payments on is going to be determined by a combination of your disposable monthly income and the amount of non-exempt assets which you possess. And then finally, Chapter 11 is also reorganization, but that reorganization is either for individuals that have debt in excess of the limits in a Chapter 13, which are generally $300,000 for personal property or $1.1 million for real property. So in Chapter 11, you're also going through a reorganization, but it's a far more complicated and rigorous process with lot more attorney work than is typical in a 7 or 13. When filing a bankruptcy under any chapter of the Bankruptcy Code, you will immediately be protected by an automatic stay under Section 362 of the Bankruptcy Code, which will prevent anyone from taking any adverse action against you. No judgments can proceed, no foreclosures can proceed, no collection efforts can proceed. And so it really is, I like to say it's like putting a cog in the wheel of a bicycle. It just stops it dead in its tracks. Very powerful tool, and it doesn't even require immediate notice to the creditor. They're subject to this rule as soon as the bankruptcy is filed. And then in your bankruptcy, you're going to go through what's called a meeting of creditors, or also known as a 341. And in the 341, the trustee will examine you, that is to say, he'll ask you questions under oath in front of a microphone about your assets, about your liabilities, about the truthfulness of the statements that you've made on your schedules, and so forth. And that meeting usually takes place in under 10 minutes. It's not in a courtroom, it's in a meeting room, and it's not before a judge, it's before a trustee who could be a CPA, an attorney, or someone else trained as a trustee. That's sort of the big picture on bankruptcy, and we can answer any further questions you have. Thank you.